I'm joined by Justice Deepak Gupta. He is a former judge of Supreme Court of India. Thank you, sir, for joining us.
Yeah.
So my first question to you is, there are nearly 5 crore cases pending in courts all across India. What is the real reason behind this?
There are many reasons. I'll just deal with them one by one. The first is we have a very large population. There's 130 crore people, so there are bound to be more cases. The second is that our judge to population ratio is one of the lowest in the civilized world. You see, even small countries like Egypt and all have the same number of judges as we have. So we don't have adequate number of judges. We don't have adequate number of courts. Another reason is that the state itself is the biggest litigant in the country. A lot of criminal cases are filed which have no reason to be filed. A lot of civil cases are defended by the state, which the state should not be defending. So the fourth is there is an adjournment culture in this country. The courts are very liberal in granting dates, and also the lawyers are very, they take it for granted that if they will ask for a date, the court will grant. Our procedures are in some ways outdated. I'm not saying that the procedures are bad, but they need to be modernized. We need to use technology much more. And I can tell you, there is when we talk of 5 crore cases, it's a huge number, it's a humongous number, and it should not be there. But if a case is pending for 1 or 2 years, I will not consider it to be a pendency in that sense. It's not like grave areas. But when a case is pending for 5 years or 10 years, then it becomes, and we are facing that problem also. So first we have to segregate those cases which are very old. Because any case, you can't file a case today and expect the decision tomorrow. Given the real situation in India, so 1 or 2 years. And I also take it, unlike others, I also take it that it shows the confidence which the people have in the Indian judiciary, that there is such a large number of cases. So there is the negative also to it and the positive to it. But we have to do something. I mean, if, about 5 years back, there were only 3 crore cases. And mainly because of COVID, that 2 years, there was no disposal of a lot of filing happened. So it's gone up to 5 crores. We need to take it up in a war. And if we don't do it, the danger is that the entire judicial system will collapse. So I told you the people have faith in the judiciary, but if they start losing faith, then they will start alternative methods of settling their disputes, alternative methods which are outside the law, which are unconstitutional, and then we are heading towards anarchy. So it's a very dangerous situation. There's a positive side to it, but there's a big negative side to it. Yes.
Okay. So as you said, if the cases are kept on pending, there will be alternative methods. So what are these alternative methods, if you can explain?
When I talk, there are alternative methods which I would welcome. Those are like arbitration, conciliation, mediation, settlements outside the court. But I am more worried that the alternative method are going to be illegal, like a landlord hiring goons to evict a tenant, like a company getting goons to recover their dues from a person. Because if they feel that the courts can't give them relief, they might some of them already doing that, so that may become good. So that's very dangerous. So to prevent that, it is in the interest of all who think of the Indian judiciary as something which is viable and should be kept alive, that we have to work forward towards a very speedy disposal system. I don't have all the answers. Let me be honest. If I had the answers, well, things wouldn't be so. We have to sit together, and we have to think out of the box. Okay. There are some solutions which I can discuss with you, but it can't happen overnight. It'll take a lot of time.
I understand. So can you name some solutions to reduce this pendency of cases?
Yeah. First, I think, there is this reluctance by all judges at all levels to take up old matters. If your file is 20 years old or 15 years old, the file becomes big. Mainly not because of the dispute, but because of the many applications filed therein. It becomes dusty. Nobody wants to touch it. Because my experience is that when you take hold of the old files, in many cases, the cases have become infructuous. The parties have settled the dispute. They've, then nothing survives because of efflux of time. So you have to take that. That is one. You have to go on mission mode too, because that will take care of the oldest cases, not all, at least. But even if it takes care of 20 or 25% of the cases, I'm sure it will take care of more. But even if it takes care of 20, 25% of the very old cases, not the new ones, of the very old cases. We also have to now look at alternative means of dispute redressal. Arbitration is one, conciliation is one, mediation is another one. We have to think of helping people to settle disputes outside. Under Section 89 of the CPC, these three alternative dispute resolution systems are almost like mandatory. But our system of arbitration is almost as cumbersome, almost as expensive. Mediation and conciliation have yet to take off in the country. So we need to expand that. There's a section in the Civil Procedure Code, Section 80, CPC, which requires that before a person files a suit, he has to give a notice against the government, that is. Before a person files a suit against the government, he has to give a notice of 60 days to the government. And the government is supposed to answer within 60 days. I joined the profession in 78, so I've completed 45 years almost in the profession. I've yet to see a single case in which the government has ever answered a notice under Section 60.
Okay.
See, when they will not, because that will require that you look into the matter, admit what is right. So when the government doesn't do it, and I'm not blaming this government, it's right down from the last 70, 80 years. It's not a question of a government, it's the system. Our system is such, no bureaucrat wants to take the thing that I admitted it. Just court ko decide karne do. So that is how we get burdened with cases more and one. The second most important is we need more and more judges. That's easier said than done, because right now we have a sanctioned strength of about 24,000 judges in the country. And about 16 or 17,000 are actually working. So we have almost 25% vacancies. See, we sometimes blame the government that the government is not creating new posts. At least fill up the old vacant posts which are lying, and then we can ask the government, see if the 25% workforce increases, obviously the pendency will come down. So fill up the vacant posts. Then expand and make more courts. You need to take courts to the remotest of villages. We concentrate on the towns. We are a very urban-centric judiciary. We don't take it to the rural areas. Then the third thing is that our systems of recording evidence, etc., have to become more user-friendly. Like you and I are talking across, you are interviewing me on Zoom. Why can't the statement of a witness be recorded on Zoom? There may be some witnesses very difficult. And it's not difficult. I can tell you that even 15 years back or 17 years back, we had an experiment in Simla where we asked doctors in PGI Chandigarh to get their statements recorded through video conference. And doctor is needed more in the hospital than in the courtroom. So if you record his statement at a time convenient to him, and most of the time their statements are formal in nature, we can do away with recording of many case evidence. And then we have to do away with this, fixed time schedules and stick to them. We are unfortunately a country where lawyers take it for granted that if they request for an adjournment, it will be granted. And the judges don't want to annoy the bar. If the request is made, they grant it as a matter of course. And that is why we never stick to timelines. If timelines are I'm not saying This will vanish, but these are some ways of reducing the work.
Okay. So as you have said, you have been into this profession.
So there's another one or two others. The Supreme Court and the High Courts need to, you have a lot of cases which have an impact and could help decide thousands or maybe thousands of cases in the trial court. They're all stuck up because there is something happening in either in the High Court concerned or in the Supreme. These two courts also must make an attempt to identify which are these cases due to which many cases are stuck up, and then decide. And then the courts below will apply. Another aspect is, that's not a solution, but why I missed it out when I was saying why there is. When we pass legislation in India, we don't have a study to see what is the impact going to be on the judiciary. How many new cases will come out when we pass a law? The Section 138, the Negotiable Instruments Act was amended and Section 138A was introduced, making the check bounce a criminal offense. Today, that is one of the biggest reasons in this country for delay of cases. I'm not sure, I don't have the figures, but I won't be surprised that out of the 5 crore cases, maybe 30-40 lakhs are only check bounce cases.
Okay.
So you pass laws, but you don't provide adequate number of judges to look after those cases. So then what happens? When you don't do a study and study the impact of a law, that is going to be the problem.
So is there an urgent requirement for judicial reforms?
There is definitely. No, judicial reforms can happen in many ways. The independence of the judiciary cannot be compromised. That is number one. There can be no judicial reform by compromising the system. I am also against, making everything into tribunals. Our experience with tribunals has not been very good. In fact, there is more delay in most tribunals. There is more delay than in courts. But we need to have many more courts. We need to have well-trained judges. And fortunately, the younger judges today are very well-trained. By and large, the new judges in the district judiciary are competent because they come in through a strict competitive examination. They are competent, they are trained well. In fact, they should be trained more into management, etc. also. Because they are not trained in management, how to manage a court. They're trained only to decide. If they are trained also to manage, then they could decide maybe 10 cases a month more or 15 cases a month more, which is by management skills.
Okay. So as you said, you have been into this profession for 45 years. So can you please share a case study where you came across a case where justice have been pending for years?
Well, there are many, but I can give you one stark example.
Yeah.
See, I joined as Chief Justice of the Tripura High Court, Chhattisgarh High Court in May 2016. And I was, I'll give you two examples from that High Court. I have this little bee in my bonnet about old cases. So I told them, which is the oldest case in the High Court? They said there's a writ petition. It was, if I'm not mistaken, it was of the year 87 or 88 from the Madhya Pradesh High Court. It had come and it was 2016. It was almost 9 years old. I called for the file and I listed it in court. The only order which had to be passed, that's what I said when I said the old files need to be looked into. The only order which needed to be passed is that the High Court had no jurisdiction to entertain the matter. It was a matter falling within the domain of the Central Administrative Tribunal. And I started my judgment with an apology to the litigants. They were a bunch of workmen. That I'm extremely sorry that this has had to happen to them in my High Court. That it has taken them almost 3 decades to get a decision that this is not the right place to come. You have to go to the Central Administrative Tribunal. Because they were all employees of the central government. So that is, because we don't, you just look. One other I'll give you. My predecessor in Chhattisgarh had done a very good job of introducing computers and all in all the courts, and data was fed. I then looked into the data and I found that there was one district in Chhattisgarh which had the highest number of old cases pending, some as many as old as 40 years old. So I called, of that district, there were about 45 judges in that district, and I called all of them to, I went to the district headquarters and I said, all of you judges come in the evening with 10 files each, the oldest 10 files, which you see, we have a national data judicial grid. So you will come with all the old 10 files. So there should have been 450 files. Actually, only about 200 files came because they couldn't even trace out the files. Or in some cases, the entries in the data were wrong. But what was shocking was that one of the cases pending since about 40 years or something was a petition under the old Arbitration Act, and which was a very simple application that the arbitrator be directed to file his award. Under the old Act, you could file that application. And that had been pending for 40 years. Nobody had bothered, neither the lawyers nor the judge. It's just simple matters, and they clog up the system. What I said in the beginning, you look at old files and you don't see what they are.
Yeah.
And I can tell you that district had about 16% cases were more than 10 years old when I got the report. Within 1 year, it had come down from 16% to 6%. So you can make a lot of difference if you just apply on.
Yeah, you just mentioned about a case which was pending for 40 years. Now, recently, India has settled, Indian courts have settled a 72-year-old case, Baharampur Bank case. So, isn't these all a serious concern for our judicial system?
Absolutely. Why? This is, I mean, it's something which is unheard of anywhere else in the world, that you don't have a decision for 50 years. I mean, these are not only cases. I as a lawyer, I've dealt with cases where 3 generations have been fighting. In the Supreme Court, I've decided a matter where probably the litigation was almost 50 years old. And I can tell you that litigation has not come to an end. Despite the decision of the Supreme Court, the parties are still fighting in the execution petition in the trial.
So, according to you, what can be the way forward? You have given measures, but in a nutshell, if you can say.
No, nutshell, I mean, there has to be cooperation between the state, the courts, and the bar. The bar is a very integral part of the justice dispensation system. The state to provide more facilities, to provide more judges, to provide, a better judge to population ratio. The high courts to ensure that vacancies are filled up. As I said earlier, you can't blame only the government. The courts are also blamed because even where the posts have been sanctioned, they are not being filled up. You must fill up the posts a year in advance so the judges get training. Next, you need to look at various laws. The government has done something in the sense that they've repealed a large number of laws, and many more need to be repealed. I think one of the laws which really needs a relook is this criminal defamation. Okay. Today, everybody is being slammed with a criminal defamation case, and because big personalities are involved, every judge issues notice. I think the time has come when the Supreme Court should relook whether criminal defamation should at all be existing in our society or not. We have to relook at whether a check bounce is a criminal offense or not. See, we have to also relook at the laws, because if you relook at 2-3 of these laws, you will see a very large number of cases not being filed. And when they're not filed, and then we have to be also very heavy on costs in matters. In India, the costs awarded are either no costs are awarded or very little. Whenever you are doing research on this subject, when you see matters being settled abroad, sometimes the case is settled only on the ground that the defendant will pay the costs of the plaintiff. and they run into thousands, hundreds of thousands of dollars, sometimes into millions of dollars. Because parties, if they don't settle, are burdened with the cost of litigation.
Thank you, Justice Gupta, for speaking to us. Thank you for your time.
Okay, thank you very much. Thank you.
Thank you.